These are cases that differentiate between invitation to treat and a valid offer. It also answers the question in the previous video. So the first scenario has to do with advertisements in catalog. The case of Partridge and Crittenden, Grainer, Son and Golf both reiterate that advertisement in catalog is not an offer but an invitation to treat. The second scenario has to do with auction sales, that is, request for bids by the auctioneer. The case of Payne and Cave explains this. So the court held in that particular case that an auctioneer's request for bids is not an offer but an invitation to treat. Bids has to do with the different prices that the auctioneer will be mentioning. For example, if someone should mention 500, another person will now go to a higher price, that is 700, 1000, etc. These are bids. The court further held in this case that the bid itself is the offer, and acceptance occurs when the auctioneer's hammer falls. The third scenario has to do with display of goods for sale in shelves of shops, supermarkets, etc. So the case of Pharmaceutical Society of Great Britain and Boots Cash Chemist explains this. So the fact of the case here is the chemist shop, that's Boots Cash Chemist, sold drugs that contain poison. And they only sold it to customers on authority of a professional chemist. So the particular shop had a resident chemist. But the issue there is that the chemist shop was operating a self-service system, meaning that you will go, pick your products, and then come to pay at the counter. So the argument there was that since the display of the drugs at the shelves of the chemist shop is not an offer but an invitation to treat for potential customers to show their interest, that the offer occurs when the customer picks the drugs from the shelves and puts it in the shopping basket provided by the chemist shop, then it will be too late for the resident chemist to advise the customers or prevent them from buying the drugs that contain the poison. Also, the case of Fisher and Bell further reiterated that display of goods in the shelves of supermarkets, shops, etc. is not an offer but an invitation to treat. The last scenario given will be treated in the next video. If you have any questions so far, ask me in the comment section. Remember to leave a like as well and share the video. Thank you for engaging in the next legal space.